Good afternoon, everyone. My name is David Gallo. I'm the director of the Aifc Academy of Law, and we welcome all of you who are joining us from across the world. So good morning and good evening to those. We're very happy that you have joined us today for the next installment of the webinar series sponsored by the Aifc Academy of Law. And with that, without further ado, introducing today's event will be friend and colleague, Professor Dr. Alexander Van de Putte. He will introduce today's event and today's keynote speaker. Professor Van de Putte's the chairman of the Aifc Academic Council. He's the chief strategy officer and the chairman of corporate governance and stewardship at the Aifc. And with that, it's my great pleasure to turn the floor over to Professor Alexander Van de Putte.
David, and that's David Gallo, of course, many thanks. It makes me great privilege actually to introduce for the second time David Russell QC. You may recall that David spoke previously on trust, and that's one of his key areas of expertise. I'm not going to read out his entire biography, but I noticed that he's the co-editor of the Oxford University Press Journal on Trust and Trustees. Now, I also need to throw a little joke in. David Gallo disclosed something interesting to me. So for those who know David Gallo, that is, his middle name is Russell. So David Russell Gallo. So he was wondering for a while whether he was an unidentical twin to David Russell QC. So they haven't fully disclosed whether that is the case, but they will obviously investigate this further. But I wouldn't be surprised if the outcome would be positive. So now let me get back to our keynote speaker, David Russell QC of Outer Temple Chambers, one of the pristine chambers in London. And interestingly is that David is allowed to practice law in quite a few jurisdictions. Of course, Australia, England and Wales, but also the courts of Dubai, New York, the Singapore International Commercial Court, New Zealand, and Papua New Guinea. I never heard of anybody who is actually allowed to practice law in so many jurisdictions. Now, what David will talk about is actually the constitutional structure of the Aifc. And he will cover three parts. Part A, that's the types of financial center. So the various types. Number two is financial centers generally. And finally, the legal structure of the Aifc. I already mentioned to both Davids that I would have to leave prematurely, so I won't be able to participate, but I look forward to listening to the recording. David, have a lovely webinar, and I look forward to listening it to later on. Thank you very much.
Well, thank you very much, Alexander, for those kind words. And it's a pleasure to be here again to talk about the way in which the Aifc is set up. This is perhaps a rather different lecture to the ones that one would give, for example, about the trust law. Because what we're concerned about this time is how it is that we have sitting in the middle of Nur Sultan, a little island in which essentially the law is English common law. This is a rather unique model. Normally, it's part of the constitutional structure of any country that it has its own laws which apply across the whole of the country. So in that sense, you might think this is a very odd arrangement. But if you think about it, it isn't really. Most countries have a framework in which laws can be developed for particular areas and for particular purposes. If you think about it, the local city council will have rules and regulations which apply within the area of Nur Sultan, but which don't apply, for example, in Almaty. So it's not immediately inconsistent with the principle that within a single jurisdiction you can have different laws. What, however, is significant in the context of a financial centre, and in particular the AIFC, is that the laws which are different are a very much wider range of laws than would be the case, for example, in dealing with planning approvals or matters of that sort within one local authority area in the Republic of Kazakhstan, as opposed to another. But next slide, please, Jeff. Our objective today really is to look at, as Professor Alexander has said, first, how it is that we have different types of financial centres operating within the world, and how we would categorise in that context the Astana International Financial Centre. I was going to move on from there to talk about how financial centres generally operate, and then turn specifically to the way in which the AIFC operates. So once again, if one wanted to go through the slides, we'll just show the next two, Jeff, quickly, so that the audience can see what it is we'll be covering during the presentation. So next one, part C, and this in a sense will be the issue that confronts you more than any other, but the point about it, of course, is it happens within an intellectual framework, and it's important therefore to look at how that framework operates. So we start, next slide, with the question of how financial centres operate generally throughout the world. And there are essentially, next slide please, three types of financial centres, if you think about it. I've called them embedded financial centres, club financial centres, and then enclave financial centres, which we'll get to in a minute. But let's start with an embedded financial centre is one where the finance part of the legal structure is just another part of the overall legal structure. So that, for example, in London, a company that would be incorporated to carry on business, say to run a shop in London, will be formed under exactly the same law as a company that is involved in running a sophisticated financial operation. I mean, there will obviously be additional laws that apply to it, but you start off with the Companies Act. And similarly, throughout the whole of the UK, subject to what I've said about local governments, generally speaking, everybody operates under the same laws. So the laws, for example, relating to dishonest commercial activity will apply to financial institutions as much as they apply to anywhere else. And typically, in a common law country, that is how a financial centre is established. And I've mentioned the examples there: London, New York, Singapore, and Hong Kong. And you might ask, what's the significance of this in the context of the common law? Why would so many financial centres operate within the framework of the common law? And the answer really is that ultimately the common law, because it is based on the notion that people can do whatever they like unless there's a law that says they can't, it's much more flexible for the development of things like commercial instruments, commercial activities. In the context of civil law, the normal question you would have to ask if you want to do something is, so well, where is the law that says you can do this? And laws, of course, can be changed, but changing laws is a complex process. So whereas in the context of the common law, the parties can really work out what it suits them to have in their contracts, In civil law, it's very much more a formal process which involves looking at the existing laws and seeing whether or not what you propose to do fits comfortably within the framework. And that goes back to the way in which the commercial law of England was first created. And it was created because the people who originally wrote the laws, people like Lord Lindley, Lord Mansfield, were themselves either from commercial families or alternatively they had relatives and friends who were in commerce, the so-called British establishment. So when it came to writing things like the partnership law, what Lord Lindley did was talk to people to find out what normally happened in partnerships, and then sought to bring that into a consistent intellectual framework. In other words, one started with what was going on in the world of commerce, and then one tried to make the law fit around that so as to create a coherent framework of legal activity. Whereas if you were in a civil law country, essentially the laws were often put together from a perspective of what was an intellectually consistent framework, but not necessarily one based on what people actually did. And that might explain why, for example, for a long time, the structured project finance section of Deutsche Bank, which is a German company, obviously, actually operated out of London. So in an embedded financial centre, the participants just have to comply with the normal local laws, together with anything specific that applies to financial activities. The second type of financial centre is what I've called the club financial centre. And that operates by saying, well, we accept that the general law is not sufficiently comprehensive, or alternatively is not sufficiently well adapted to address the needs of people who are engaged in the provision of financial services. So one creates a special system of law for them. Now, as with an embedded, unlike an embedded financial centre, you will need normally a separate legislature to create the laws that are going to apply within the club. You will normally need a special set of judges because commercial courts deal with a lot of issues that don't come before judges who are exercising a more general jurisdiction. So you need to have a specialist legislature and a specialist judiciary to bring into existence and to administer the laws which apply. But the key difference between a club financial centre and an enclave financial centre is that you become subject to this special legal regime by joining the club. And the example that I give there is that of the Qatar Financial Centre, which doesn't actually operate out of a geographical area. It operates instead on the basis that by signing up for the club, you become bound by its rules. Next slide, please. The final type of financial centre, which is the one that describes how the Astana International Financial Centre operates, is that you actually have a geographical boundary, and things that happen within that geographical boundary and within the jurisdiction are subject to the laws and institutions that apply within that geographical area. As I've said, that typically you'll find them in civil law countries. As with the club financial centre, you need a separate legislature and a separate judiciary so that you have the necessary specialisation and you can create the laws that are required for that centre on the basis that you don't necessarily need such complex laws in the more general jurisdiction. The other aspect of this is that because the international finance largely operates on the basis of English law and therefore English language, you often get, as you get in Astana, the law is actually written in English rather than in the local language. That's to enable the participants to readily comprehend what their obligations are. It would be ridiculous to write the laws that are to apply generally in Kazakhstan in English, but those laws that apply to people who are engaged in international finance, it is sensible to write them in English. The other great advantage of using English law as a template is that one of the great difficulties is always to create the necessary level of certainty so that participants in a market know exactly what they can and can't do. And the easiest way to get certainty is to be able to look at what's going on elsewhere and say, well, this is what the law says. For example, the law of partnership says in the Astana International Financial Centre, it's worded in a very similar way to, say, the English Partnership Act, as it is. And so we can look to what courts in England have decided the English Partnership Act means in order to get a likely prediction of what a court confronted with a similar problem will do if the issue arises in the Astana International Financial Centre. And once again, having a specialised judiciary with knowledge of what goes on elsewhere provides you a very useful advantage in that regard. Next slide, please. Now, the second question, I suppose, the great question before we go to the details of the Astana International Financial Centre is why would you have one in the first place? What's the point? Why do you need them? And what do they achieve? Next slide, please. Now, here, the issue, first of all, is what are called free zones, is the expression that's normally used to describe separate areas like this and how they work. I'm going to look then at why it was considered worthwhile to establish a financial free zone in Astana in the form of the Aifc. I'll look at the general approach to organisational structure across financial free zones and their main characteristics. And finally, once again, the usual framework within which such a law operates. Next slide, please. This is a classic definition now where, first of all, it is a designated area. So we are talking about an enclave system. Firms operate and they're normally established. They don't have to be dedicated to finance. You often find free zones, for example, in areas, in countries where you might be wanting to have a manufacturing hub, but not be wanting to have that hub subject to domestic rules in relation to product, customs and the like. And a good example would be if you want to have a free zone that imports goods, makes them up and exports them. So there is little or no interaction with the domestic market. Now in that situation, there isn't much sense in applying the rules that are applicable to the local circumstance and regulation. What you're looking for is how international standards operate. And so the concept of a free zone isn't limited to a financial centre, although of course we are talking about a financial centre and therefore a financial free zone. It follows from that, as I said, that they're separated from the legal system of the country and normally offer a more business-friendly environment. And that can be business-friendly in a number of ways. For example, it's frequently the case that countries have local ownership laws that require that particular types of assets, particularly land, are held by citizens. That can complicate international trade. And so the idea is that within this small defined area, we ask the question, what is necessary in the public interest in terms of regulation? Do we need to have the extensive sets of regulation that are necessary for things like preserving local ownership of the economy, ensuring that commercial activity provides appropriate levels of consumer protection. But then, because you're dealing essentially with commercial activity, it's very much easier to say that the parties concerned are sophisticated and therefore don't need the level of consumer protection that is applicable if you are dealing with the public at large. Similarly, you might well say that the type of person who's likely to be employed in such a free zone, you may find that they are extensively people who are immigrants, so that it's not a question of protecting local citizens from foreign employers. You might well simply, if you're dealing with a free zone that is wholly concerned with import and export, but not dealing with the local economy, there isn't much logic in having a separate customs system for that. So you might exempt it from the local requirements there. And similarly, you might well look to have a competitive tax regime. So the key point in a financial free zone is that you are competing, but competing on an international level rather than on a local level. You would hope to have economies of scale that come with that, and also economies of scope, in the sense that you will have a capacity for people to work together with colleagues, and in that sense there is you get synergies, and that takes us to the next slide, because what you will get in a free zone is a cluster of people who are doing much the same sort of thing. Now, one of the areas that has been increasingly studied in the context of economic development is the concept of a cluster. And in one sense, yes, what you're doing is rounding up, you're getting, in the context of financial free zone, bankers, lawyers, and accountants working together, so they get to, well, compete against one another. So they obviously develop their skills. Within the cluster, you can reduce the barriers to entry. Most importantly, you get a transfer of knowledge, technology, and management skills, and therefore increased innovation and productivity, and you diversify the economy. So the point about establishing the free zone is that you get sustainable growth and competitive advantage over what you might have elsewhere. Next slide, please. So why, in the context of, I mean, you can have, again, a cluster can be almost any type of activity, but you see it in Astana, or Nur Sultan, is a cluster in the sense that it's a cluster of government activity. It brings together the people most concerned with the administration of the country. You might go on the alternative to, say, somewhere like Almaty, which is more of a tourism cluster as well as an industrial one. But the advantage of a financial centre is that you're bringing together the banks and other financial intermediaries. And because they're centres of finance, they're very much involved in the attraction of foreign direct investment and directing investment and growth, directing investment particularly towards innovation. And you'll see, I mean, if you only got to look at the third dot point, if you think in terms of places like Singapore, Hong Kong, London, New York, you can see that the cities get economic advantages because of that activity going on with them. And then from the perspective of a new financial centre, you get the opportunity to network with those global financial centres so that you get some of the benefits of what's going on elsewhere. And all of this is created by the way in which policy decisions are made. Next slide, please. Now, looking at the existing international financial centres, you can see cities that are facilitating capital flows both domestically and internationally. And classic examples of that would be London and New York. Cities that, because of locational advantages, serve as regional financial transactions and do a lot of foreign currency work. Singapore and Hong Kong fall very much into that category. Then you can have centres that are essentially developed to provide a platform for foreign financial transactions without much in the way of internal transactions themselves. And Bahamas, Cayman Islands and the Channel Islands are good examples of that. People use the term offshore financial centres because they are financial centres that are operating without a substantial economic base in the jurisdiction concerned. They rely very much on transactions elsewhere. And then you have the type of financial centre that operates as a bridge between the home jurisdiction, its home jurisdiction, and the wider capital world of capital. And Dubai provides a good example of that, although you might say the same about Singapore and Hong Kong. Next, please. So you might ask, why would the Republic of Kazakhstan decide to proceed with the establishment of the Astana International Financial Centre? The location is important because the types of functions that they perform and the functions that give rise to them are very much dependent on where it is. You'll have seen from the previous slide that the various financial centres that I've identified perform quite different tasks or have principal obligations that are unrelated, that are related very much to where they are and their operation in the international financial system. So why Nur-Sultan? Well, it's a matter of history that the AIFC was established as part of the Expo and was part of a decision by the government to create a freer economic system, properly registered, properly regulated, provide for relatively free entry of foreign banks and bankers, which in turn will bring about the availability of educated, multicultural and well-seasoned professionals. And as a centre of government, Nur-Sultan has access to that as well. And also then the opportunity to develop legal systems based on property rights, contract law, a functioning court system and bankruptcy processes provide something of a model, some of which over time will be relevant to Kazakhstan more generally. Other parts of it, no doubt, will remain restricted to the financial centre as a whole. But Kazakhstan is obviously a very wealthy country in terms of its resource base. And clearly, the reality is that there will be a great deal of financial activity that is connected with the development and exploitation of those resources. And the choice for the government of Kazakhstan is really whether or not it is going to have that activity going on in Nur-Sultan in part, as opposed to letting it all go on in London or Singapore or Hong Kong or Dubai, so that the benefit of the skills base that's developed all operates to benefit other countries and not Kazakhstan itself. Next slide, please. Now, if we then look at the models that have been developed elsewhere, the embedded IFCs have traditionally been established by virtue of a special law that allows the setup of the financial free zone. And it normally will have the following characteristics. First of all, there will be either no or very limited corporate and personal taxation. One of the reasons why you might want to select a taxable regime is that the international tax system is increasingly moving in the direction of not permitting companies to operate or discriminating against companies that operate in totally tax-free environment. That, to the extent that that model is extended, and you're seeing it now, particularly with digital services, the choice that a country like Kazakhstan might face in the future is either that it will collect the tax and have the benefit of the revenue, or the countries in which the company or the entity in question carries on business will impose the tax and keep the money for themselves. So it's obviously sensible in such a case for the money to stay in Kazakhstan rather than go overseas or offshore. As I mentioned, you will normally have a special financial court because it's administering laws that are not common to the rest of the jurisdiction. You need, of course, somebody to administer the zone, to create the laws, to make sure that the financial services are properly operated, and that because we're talking about an enclave, an area, a geographical area, making sure that the other requirements of such an area are attended to, the things that a local government would do. And finally, ensuring that the financial markets operate in accordance with world's best practice. Because if that doesn't happen, one of the things you obviously want to do is to have a relatively seamless interchange between the activity of within the free zone and international financial markets. And if the standards of regulation and operation are not seen as being comparable to international best practice, you don't get let into that club, if I can use the term. Next slide, please. So now we go to see just exactly how all of that has been given effect within the context of Kazakhstan. Next slide, please. Now, the starting point, obviously, is the Constitution of the Republic of Kazakhstan. There are, of course, this and a couple of the other laws I'm going to refer to are documents that are written in the Kazakh language. So this is an unofficial English translation, and sometimes it's not particularly, the translation sometimes can be difficult. But we start with Article 2 of the Constitution of Kazakhstan, which first of all establishes the notion that Kazakhstan is a unitary state. So in other words, it's a single jurisdiction subject to the capacity of that jurisdiction to create laws across parts of the jurisdiction that differ. You'll see that the sovereignty extends to the whole of the territory of Kazakhstan, and then the capacity to establish a financial free zone arises under Article 2.3-1, which provides for the creation of a special legal order in the financial field. So at the moment, there is no provision for the establishment of other free zones, only for financial free zones in the Constitution of Kazakhstan. That, of course, doesn't establish anything. It simply makes provision for that to occur. And the power to do that is the power that's exercised in a law called the Constitutional Statute of the Republic of Kazakhstan. Next slide, please. Now, it provides for the establishment of the Astana International Financial Centre. Specifically, it provides in Article 4.3 for the making of what are called AIFC acts within the geographical area of the Republic, of the laws of the AIFC, and the term that's used in Article 4 of the Constitutional Statute is the acting law of the AIFC. Now that's a term which we'll be coming back to quite a bit, but it says, I've only set out a key part of it there, but if you read the whole article, it provides essentially that the acting law of the AIFC is based on the Constitution of Kazakhstan, and it consists of the Constitutional Statute. You might call that the founding law in another sense. Then AIFC acts, so they're laws that are adopted by the AIFC bodies in the exercise of the powers given to them by the Constitutional Statute. The acting law of the Republic of Kazakhstan, so one has what I might loosely call a bedrock law, which is the law of the Republic of Kazakhstan. And then, well, those are the three sources of law. And then Article 4.3 makes provision for laws to be created within the AIFC by the AIFC bodies. Now, the AIFC bodies are essentially, it comes back to the Council of the Astana International Financial Centre Management. That is a separate statute, which I'll come to in a minute. But in Article 4.3, the limits of the AIFC bodies to adopt acts, first of all, that they must regulate the relationships between AIFC participants. Now that's a registered person if you were going to talk about the club model. AIFC bodies, which are entities established for the purposes of administering the AIFC, their employees, AIFC participants and AIFC bodies, AIFC participants and their employees, AIFC bodies in relation to civil relationships, civil procedural relationships, financial relationships, and administrative procedures. And in the cases provided for in the Constitutional Statute, the AIFC bodies may adopt acts governing relationships that are not covered in the first part of the paragraph. So it's fairly wide capacity to create laws, but you'll note that it doesn't include criminal law. So the criminal law of the Republic of Kazakhstan applies throughout the AIFC, quite independently of anything which the AIFC bodies themselves may want to do. Then get to how the law is made, and that is adopted by another, and this is another law of the Republic of Kazakhstan. Whilst it's available on the AIFC website, it is nonetheless a translation, because one is bound by the laws of Kazakhstan. And essentially, and critically for present purposes, the AIFC Council, which has a composition which ensures that it is operational and will fall within the overall policy of the Republic of Kazakhstan. The composition includes the President of the Republic, who's the Chairman of the Council, the Prime Minister of the Republic, who's the Deputy Chair, the Governor of the National Bank, the Minister of the Economy, the Ministry of Finance, the Governor of the Centre, and then there are 4 other individuals who've been appointed on the basis of their special skills. And that body has the power under Article 5.7 of the law to adopt laws that are that will bind the will be binding within the framework of the. No, sorry, I've said Article 5.7 there. That's actually incorrect. Yes, it is 5.7. The section or the chapter numbers of the laws aren't the same as the section numbers. But Article 5.7 provides that the Council adopts AIFC Acts in the form of resolutions on matters within its competence as specified in the constitutional statute. Next slide, please. No, sorry, I have dealt with that. I should have had that slide, mentioned that slide going through. That's, we can move on to the next slide. You'll see I've referred on a number of occasions to AIFC bodies. You'll see that there are 6 of them actually specified in the constitutional statute in Article 9, and all of them have, to varying degrees, lawmaking powers, although, as we'll see as we go a little further, they are essentially all bound by, they all come back to the Council. If we go to the next slide, you'll see that the Management Council adopts AIFC Acts in the form of resolutions, and I've mentioned that to you already. We then look at what the AIFC bodies do, and the first is the AIFC Authority, which is the general administrator of the centre, and it develops draft council resolutions, draft provisions. It agrees, it has to work obviously with the Financial Services Authority. It has a process of public consultation for the creation of what will be council adopted laws. And then it has a power of its own account to adopt acts in the form of regulatory provisions on matters not relating to the regulation of financial services. So there are 2 levels of law that can be created by the AIFC Authority, one that involves the approval by the Council, and one which requires which it doesn't. We see the same, next slide please, in relation to the Financial Services Authority, insofar as it is developing draft acts in relation to the regulation of financial services. They are matters that obviously have to go to the Management Council for approval, and then there is the capacity to create subordinate legislation, which doesn't require approval by the Council. And the independence of a financial services regulator is a critical aspect of the operation of a financial centre, because it's at an international level, arising through things like the there are a series of international bodies that actually rate financial centres to ascertain that the very substantial powers that are given to financial services regulators are not misused and are applied in a manner that's consistent with the standard of international financial centres. And within the framework of the financial centre, the financial activities, the key provisions are, first of all, the AIFC framework regulations, which is a law promulgated by the Management Council. And the key provision there is Section 24, which has a general provision on a general prohibition on the provision of either financial services or ancillary services, unless they have the approval of the Financial Services Authority. And those terms are defined by the Financial Services Authority itself in what's called the AFSA rulebook. And in Schedule 1, you'll find a definition of financial services. So within the financial services, the key point basically is you have the basic prohibition of financial services and ancillary services. And then once you are within that area, you have to get consent and you become regulated by the AFSA. The court is the third pillar of whilst I've talked about 6 AIFC bodies, the court is really the third pillar of the centre. And again, we go back to the constitutional statute, and you'll see that the AIFC court is created by the AIFC court regulations, but the constitutional statute gives the court of first instance exclusive jurisdiction in relation to the hearing and adjudication of the following disputes. And as you'll see, it's a fairly wide jurisdiction once matters are connected with the AIFC and are governed by its acting laws. And then we get to the question of, well, what is the law? And you'll see that as I've previously discussed, the law is formed in accordance with Articles 4 and 13(6) of the constitutional statute, which is picked up by the court, the AIFC court regulations, and you'll see the starting point is that the court has to apply, and the term that's used here is sorry, I've gotten a few slides behind. Next one. Yes, and the next one. You'll see that we start with the constitutional statute, the AIFC regulations, and the court rules. And then the parties have the power to adopt a law of their choice for their disputes if they wish. Now that won't apply if you're dealing with one of the centre bodies, but it will apply, for example, in relation to private contracts. So it's perfectly proper, for example, for 2 parties who are carrying on business in the AIFC to agree that English law, Kazakh law, or for that matter, Chinese law, will be applied in the resolution of their dispute, subject obviously to the requirement that you can't adopt a law whose legal principles are fundamentally inconsistent with those of the Republic of Kazakhstan. Now, if we haven't gotten an answer from the AIFC laws or the parties' agreement, then the court will adopt the law that seems to it to be the most appropriate in the facts and circumstances of the dispute, which would normally be determined by what the parties have agreed to do, where they've agreed to do it, and the nature of their fundamental operations. I mean, it would be relevant, for example, where they're incorporated, what other business they do, and the like. Next slide, please. And then we get to what is called the waterfall provision, that we go through, in a sense, a series of choices that arise. And if we look at the next slide, please, we'll see that we go through the requirement, first of all, that you look to the AIFC laws, then you look to the laws agreed by the parties, then you agree to any law that appears to the court to be appropriate to be taken into account, failing which the acting law of Kazakhstan. Now, this is an area in which the AIFC have departed from the model that has often been used in creating these laws, which is basically the laws of the DIFC in Dubai. because in the DIFC, the default law is the law of England and Wales. And given that most of the laws that have been written are written from a perspective of the common law, there is a logic of falling into the laws of England and Wales as the default law. The policy decision was obviously taken in Kazakhstan that it is appropriate, whilst the parties can agree to go elsewhere, if they haven't satisfactorily done that, or if it isn't clear where they wanted to be or what is an appropriate jurisdiction, then it will be the law of Kazakhstan which prevails. Now, what that basically means in contracts is that you need to be very careful to actually have a law which defines what the parties, or a choice of law clause, so that there's simply no argument. Because there can be some inconsistency between the approach of, for example, an Aifc Act, to the extent it isn't fully comprehensive, and the law of Kazakhstan, because the Aifc Acts generally proceed on common law principles, whereas the law of Kazakhstan will not. This was an issue, for example, when drafting the trust law. We had to make sure it was very comprehensive, so that there wasn't an issue that might have to be resolved by the acting law of Kazakhstan, which of course doesn't make provision for trusts at all. So it is a significant issue, and one that makes it quite important that choice of law clauses be properly drafted. Next slide, please. The next question, from a court perspective, is once we've got a court order, if we've won, will you be able to enforce the court? Will you be able to enforce the order, first of all in the Aifc, then elsewhere in Kazakhstan? If it's a trust, whether you might be able to do something about it in the Hague Convention country, whether you can do so in other common law jurisdictions and in other civil law jurisdictions. And you'll see I've said there that the answer to all but the last of those is yes. In relation to the Aifc, of course, it's fundamental. The court is established within the Aifc. It's given judicial power in the Aifc. So it's given exclusive jurisdiction, actually. So it's inevitable that its orders will be enforceable within the Aifc itself. If we go to the next slide, please. So far as Kazakhstan itself is concerned, the law is perfectly clear. The constitutional statute provides that a decision of the Aifc courts will be treated as if it's a decision of the courts of the Republic of Kazakhstan. So it will be a very simple matter to enforce Aifc court judgments in Kazakhstan. You simply need to require a provision for translation of the judgment. And once you have that, you treat it in the same way as, it will be treated elsewhere in Kazakhstan as if it were a decision of the local court. Might be worth saying a bit about the other two areas, or the other three circumstances in which you might be wanting to enforce a court order. If you're dealing with a trust established in the Aifc, you may want to enforce it internationally. There is an international convention called the Hague Convention, which relates to the enforcement of, or the recognition and enforcement of trusts. And it effectively provides that signatory countries will ensure that their legal systems recognise the existence of a trust, recognise that trust property is separate property from the ordinary property of the trustee, and recognise therefore that you are dealing with a effectively different class of assets when you're dealing with trust assets. because otherwise in a civil, particularly in a civil law country, the consequence of a trustee developing a personal liability is that trust assets could be relied upon to satisfy the trustee's liability. The Hague Convention, particularly in civil law countries, prevents that result. Now, it's important to point out that the Hague Convention is a convention that is an open convention. What I mean by that is it doesn't matter that Kazakhstan is not a party to the Hague Convention from the perspective of any AIFC trust. It will be treated in exactly the same way in a Hague Convention country as it would be if Kazakhstan were a party to the Hague Convention. What it does mean, of course, is that a decision in relation to a foreign trust won't be enforceable in Kazakhstan, whereas a decision in relation to an AIFC trust by the AIFC courts will be enforceable in Kazakhstan. So it is not correct to say that it doesn't matter that Kazakhstan has not signed the Hague Convention, but certainly so far as AIFC trusts are concerned, it doesn't matter. I'm sorry about the lettering on these lists. I've obviously I've got 2 Bs and no D. Common law, you actually don't really need the Hague Convention in a common law country because foreign trusts generally will be recognised. The only importance of the Hague Convention is where you have jurisdictions where a trust would not be recognised under local law. For example, a purpose trust, generally speaking, won't be recognised in English law if it's not for charitable purposes. And a trust which contravenes the law against perpetuities would usually not be recognised. The effect of the Hague Convention is to ensure that provided a trust is valid according to its own proper law, then it will be treated as valid in a Hague Convention country. But apart from those limited situations, the common law will normally recognise a foreign trust and therefore an AIFC trust. So far as judgments are concerned generally, as opposed to matters involving trusts, the common law approach is to treat a judgment of a foreign superior court of record as creating a cause of action in its own right. You don't need a law for that, that's just the general principle. So that a decision of the AIFC court, for example, in relation to payment of a debt, will, in the absence of some specific local law which produces a different result, simply be capable of being sued on as a judgment, rather than having to go back and prove the whole cause of action again. Whereas in civil law jurisdictions, a judgment of a foreign court usually, although there are now a number of international conventions that deal with the matter, but normally a decision in relation to of a foreign court has no particular advantage from a point of view enforcing the liability. You would have to go and sue in the country concerned. I think that covers pretty much everything in terms of the constitutional structure. Happy to answer any questions that anyone may have.
Thank you, David Russell. Almas, do you have any questions that have come in from the audience?
Yes, as of now, we have 2 questions. And the first question is, what is the constitutional particularity of the AIFC? And the second question is, what is the main difference between AIFC and the AIFC's constitutional structures?
Sorry, can you repeat the first question again?
What is the constitutional particularity of the AIFC?
Well, it's not particular in the sense that it is established in any very different way from other financial centres. I mean, it differs from the structure in the UAE because the UAE is a federal system. So you have to have you effectively have the federal constitution permits the establishment of financial free zones in which the civil and commercial laws of the federation don't apply. But the founding law, as we call it, in the DIFC and its equivalent in the Abu Dhabi global market are actually emirate level laws. So you have to have at each law has to, in a sense, carve out at each level you have to carve out the operation of local laws. In terms of, but apart from that, the model is a reasonably, well, it's pretty much the only way you can do it. You have to start with something in your national constitution which provides for the establishment of special jurisdictions, and you have to provide for the extent to which they can depart from the national law within those jurisdictions. I think if one were to identify a particular area of distinction, it's probably in relation to the composition of the Management Council. I went through that list before, but you'll see that it is very much a council that is can be guaranteed to reflect the policies and intentions of the Republic of Kazakhstan. The president is the chairman, prime minister is the deputy chairman, then you've got the chairman, the governor of the National Bank, the minister of the economy and the minister of finance, and the governor of the Astana International Financial Centre. Now, all of these are, all of them, and for that matter, the other four members are all appointed by the government of Kazakhstan, and in that sense, they could be removed. But it is very much a creature of the national government, and it's very much to be expected that its policies will be very much aligned with those of the national government, whereas in both the Abu Dhabi global market and the DIFC, well, in the first place, the membership of the governing bodies is appointed by the emirate rather than the national government, and certainly don't have the high-level participation that you have in Kazakhstan. I doubt if, whilst, well, for example, the President of the United Arab Emirates doesn't even get to approve the laws of the DIFC or the ADGM, let alone participate in making them. There's obviously a limit to how far financial centres can go independently of what a national government wants, but at least within the Emirati context, there's a lot more in the way of formal independence and far more capacity for the financial centres to develop their own ideas and strategies than is likely to be the case in the AIFC. Does that answer the question?
I hope so. As of now, we have no other questions, and we can finalize and conclude. David?
Okay. Thank you very much.
Great. David Russell, on behalf of the Academy of Law, we very much appreciate and thank you for your fabulous and highly relevant presentation on the constitutional framework of financial centers generally, and then more specifically at the AIFC. So you are welcome back anytime to join us for these learning and development activities here at the Academy of Law. And we look forward to seeing you again soon.
Thank you so much.
And to our participants, thank you. Have a great day. Stay safe, stay positive, and we very much respect that you continue to move the goals and objectives of your law firms and your companies forward during these interesting times. And please stay tuned. We have a number of very exciting certificate programs, international qualification programs, and so forth coming up shortly. We certainly will be publishing that information to make it easy for you to join in. Thank you, everybody. Have a great day.
Great, thank you.